Legally Speaking with me, Tarun Nangia. Today is a very, very interesting episode. The Supreme Court bench headed by Justice Krishna Murari, the Supreme Court bench headed by Justice Indira Banerjee and Justice Krishna Murari upheld that allegations of extramarital affair against a woman does not make her a bad mother. Now, it is a very significant judgment by the Supreme Court in the sense because this reasoning was used to give child custody to the lady in concern. Child custody was allowed because the Supreme Court held, and I again repeat, that allegations of extramarital affair doesn't make a woman a bad mother. And the senior advocate who argued this matter is our guest today. I would like to welcome Senior Advocate Pinky Anand, who, as we all know, has served as the Additional Solicitor General of India. Ma'am has kindly consented to agree and come on the program. Thank you so much, ma'am, for joining us today.
Thank you, Tarun. Indeed, it's a delight. I think sometimes you come across these situations when you feel very gratified. So you feel gratified when you can do justice, and justice particularly to children in these, of course, very troubled times and trying times. I think you feel really vindicated, and these are the spots of bright light that come across, and you feel I was able to do something for the cause of justice, the cause of women, the cause of children, and really go in that direction.
So, Justice Indira Banerjee and Justice Krishna Murari, you argued, they agreed with your argument. What were your first feelings when you heard the judgment?
I was actually thrilled. It took quite a while, incidentally. It wasn't a short hearing. And as you might know, I don't know if you do know the details, but basically this case arose out of a guardianship petition, which was filed by the father in the trial court. And there before the district court, the custody of the children was awarded to the father as an interim measure. Of course, this is interim custody. This is not the final custody, by the way. That means that there will yet be another determination. The marriage was a long-lasting one to that extent. The children were about 11, and the girl child was about 4 years of age, at that time a little lesser. And the court heard the various submissions. But what really was bewildering was this. There were some allegations made about an extramarital affair, which the lady, who's a school teacher, by the way, of course the names are not going to be out here, but who's a school teacher, was supposed to have had with somebody. And believe it or not, I don't want to go into the merits of the situation, but it was very, very peculiar, even the allegations which came. And incidentally, what I always feel is that the easiest way to discredit a woman in such kinds of matters, or even otherwise, is to cast aspersions on the character. I mean, moral allegations are so easy. And once put, the blemish actually seems to cover it all the territory. And then you are disqualified by anything. So a general perception and a bias which is attempted to be created. And generally the mindset used to be in that fashion, that if there are allegations, forget proof. Where was a question of proof? Some documents produced to say the girl and the boy were meeting. Some documents produced to show that emails were exchanged between the parties, going no further than statements across with each other, and they were colleagues. Emails produced to show that some gifts were made, and they're very highly disputed, by the way, where the gifts came from or where they were supposed to come from. So this is the total level of the allegation, but obviously the circumference was such that the attempt was to create a bias in the minds so that the children remain with the father. Now, incidentally, it's a very agonizing situation. In any case, I always feel this custody battles are agonizing because you have two parents, and this is not to say who is necessarily good and who is necessarily bad, but the trial court, the district court, when hearing the matter, based himself primarily on, and I re-looked at this part of the order twice because I couldn't believe it. I said extramarital allegations have been made, and the trial court actually grants interim custody to the father based upon allegations, while saying that the allegations of extramarital affair have not been proved and they've only been made. But nonetheless, the basis was this. There was some other basis, by the way, which could have been possibly argued. In any case, this was the basis the trial court went. So the matter went to the High Court. The High Court itself not only examined the matter itself, but appointed an amicus curiae. Now, amicus curiae is a friend of the court, as you know. Of course, you've been hearing the recent episodes of what has been going on, but this is another territory. Amicus is a friend of the court and a friend of the people. There's no cause to which the amicus is attributed aside from justice, to assist the court as a friend of the court. So an amicus was appointed who interviewed the children. And the children categorically stated that they wanted the elder child because the younger child is too young. It's a female 4-year-old child What is she going to say? The children made categorical avowals that they wanted to be with the mother and they were happy with the mother, and the fact that they would wither away if they didn't go to their mother. There was, of course, visitation granted by the district court while granting the custody to the father. But even that was a matter of really sad exercise. I won't go there for a moment. So the High Court, examining the factors of the interview, the amicus's report, which incidentally is confidential. So there's nothing that we have with the amicus report, excepting what the court has reported because it was sealed by the court. The amicus made a categorical finding that the children wanted to be with the mother. The mother is a school teacher. The mother was staying with her parents, staying in a house, in a family home. She was able to, according to the High Court, be able to take care of the children in entirety. There were some issues of financial issues. By the way, the first impression that was given to me was possibly there was an issue of financial implications, that the mother wasn't as well off as the father. So whether the mother would be able to take care of or not. And by the way, on that platform, I would also say that financial issues can never be the reason for granting custody one way or the other. Whichever parent has to have custody must have custody. Whichever parent has the financial means must give over the financial means if you don't have it yourself. But that is the way the law has developed and should develop, and the only way you can actually have evaluation of that. So the High Court granted custody to the mother in clear, unequivocal terms to hold that the best interest and welfare of the children was to be with the mother. And both the children should be together, they should not be separated. And that was the basis. The husband or the father came to the Supreme Court, as you know, in the hearing, challenging the High Court order. And the Supreme Court now, what was fascinating with it was the Supreme Court didn't straight away do anything to dismiss the petition. The Supreme Court actually went through the High Court order, actually went through the submissions of the council. And the council tried his best to make avowals about extramarital allegations. Believe it or not, when that is what is so dismaying. How does the factor of any kind of moral issue become the basis for giving the mother custody or not custody? For example, one of the arguments made by one of the counsels is also this. What about if a person is a prostitute? I'm sorry. The question is a prostitute not allowed to be a mother? If she is a mother, can she not take care of her children? Is she disqualified to be a mother or to have custody of her children because she's a prostitute? And I'm going very far out because prostitution is quite another game. Please, let's not confuse. It's not this case. It's just a statement made visibly to show what the basis could be. But be that as it may, the entire attempt was to, in that sense, create, possibly, I can only say this from what happened, to create a prejudice in the mind of the court that because there were allegations of extramarital affair against the lady in question, therefore she should not be given the children. And the court, in clear terms and very patiently and very quietly, in a sense, it was very, very subdued statement made by the court, but nonetheless affirmatively to say, what does it mean if a person is, even if the person is having extramarital affair, does she become a bad mother? Does it give her a ground, or does it give the other side a ground to disentitle her for custody? And the matter went on for a fair bit of time. I must say, you know, in Supreme Court, normally matters don't go on for too long. But nonetheless, this was heard. Every possible, the emails are pointed out, the statements were pointed out, the exchange of communications was pointed out, incidentally, which had nothing in them. But that's another story. As I said, we're not going into the merit.
I want to understand from you, after this judgment, allegations of extramarital affair cannot be used as a ground to deny child custody to any mother.
See, the way it stands, yes, it will be a precedent. But believe it or not, Tarun, in family matters, most cases are built on facts. So you can't ever say that some avowals cannot be made or would not be a ground. People will continue to make grounds. To what extent courts will regard them will always be in its own facts and circumstances. For example, I'm saying there could be other instances or some other issues which are connected. So it could be a factor in consideration. It should not be the only factor which disentitles you. But to say that it would never be a factor, I would not go so far as to say that, because supposing, just for discussion purposes, if you have an extramarital affair and you are actually neglecting the children because of that, now let's take that as an example. And that would be something else which would not come within this frame. But I don't want to go beyond this statement. I'm just giving you one of the examples which could possibly weigh in as a consideration, because what is the ultimate criteria is the best interest and welfare of the children. So the best interest and welfare, supposing the children had some animosity, that would be another matter. But simply because you aver, simply because you allege that the mother is having an affair with another person, cannot be the ground to disentitle her for having custody of our children. And that, I think, is a very fair square peg in these times, in these troubled times, even more so. You want sanity, you want the interest of children, you want security, you want the best wishes of the children. And when the children are clear in what they want, I mean, imagine the circumstances. You have a well-qualified lady. In fact, the children, for example, would have got admission in the school because of her being a teacher in the school in the first instance. Good schools, good education, good children. They want to be there. This is the way the courts have actually looked at it, and I'm delighted because it really sets a precedent fully in the circumstances of the present case. Of course, I qualify that to say that you cannot have this as a SOPA.
Okay. So I want to understand, in the courts across this country, when lawyers read this judgment, will it mean that the course of a lot of cases all over India will be affected also, because it can't be used as a one-way ticket by one party to level allegation against a woman and deny her the right to child custody? Because Indira Banerjee and Justice Krishna Kumari and Justice Indira Banerjee have clearly said that allegations of extramarital affair does not make her a bad mother. So the honorable judges in that sense have made it clear, and that will impact all cases from now on.
Because yes, you're right. You're right. When there are only, I must have one statement which I'll make a little later, but the point is, yes, the court has made it very clear that extramarital affair by itself cannot be a ground to disentitle a mother for custody, and that will have resonance across the country, across the courts, and thanks to further discussion on these kind of issues, the resonance will increase and should increase, because really speaking, this is the only way that justice can be dealt with, particularly dealing with, very, very precious, very sensible, very small children who need to have this sanity, as I said, in their lives. They're growing up, the security, the warmth. In fact, this was another issue that the court does. And by the way, what the court said and what the court, of course, has in the order are two different things. But the court did bring up constantly the age of the younger female child. The child was under 5, and there is almost no substitute for a child at that age for the custody to be with the mother and nobody else, unless and until there were any circumstances to do that. Now, that, as you know, the law is also well settled on that. But aside from the law, the court was so cognizant of the fact that the tender age of the child required and necessitated the custody and the warmth of the mother.
So very interestingly, the court has delved into detail. So, but you also explained to us one more thing. This can't be used like in commercial or matter of commerce or commercial cases as a single window to deny all fathers custody. But this will influence the course of cases to a great extent, where women's reputation is being maligned with the sole intention to not give her custody.
No, that's what I was trying to talk to you about, to say that this actually will become a precursor to a narrative.
Okay.
This world over, what we are trying to do is to change the narrative to ensure that you can't in any manner stigmatize or stereotype or cast aspersions. This also indicates that you can't have a bias, and because of a bias, prejudge an issue, and because of that bias, decide one way. So the question is today, cannot be the substance or the gravamen of anything to have the court decide in one manner or the other. Because the easiest part, I repeat again, in the case of any kind of contest, and why only family matters, but more so in family matters, is to raise allegations of this kind. To say she is having an affair, she's a loose woman. And the same thing applies across. In sexual offences also. In sexual offences also, you have these typical statements being made. She's a loose woman. She deserved it. And that has been the subject matter of so much discussion.
Does it happen in the court where such allegations are made against women, where she's a victim?
Of course, they are. And they are constantly made across, and they've been, ultimately advertised in the recent judgment that the Supreme Court has given also. It does put a fair bit of attention on this factor to say you just cannot do that. You can't character assassinate. You can't raise aspersions. You can't humiliate. You can't be insensitive. These are some of the hallmarks, and today we are very fortunate to have a very pragmatic Supreme Court, which ultimately is extremely sensitive to the needs of the hour and to the needs of the so-called disadvantaged, if you want to put it in this fashion, or to say more particularly, to rise to the occasion in favor of women, and to ensure that every kind of protection that can be given in terms of law and the substance of the Constitution is given.
And I want to understand from you for a fact that greater numbers of women are working in cities in offices. They work longer hours as much as men do. And a lot of communication via WhatsApp, other mediums does happen. And it can be informed and misinterpreted, and women can be maligned, and it does happen. Do you feel that the Supreme Court's approach in that sense is a very progressive one, keeping in times with the needs of the society? Society has changed in the past 60 years. Women are now much more, in a sense, when you started your career in law, things may be different, but now they're completely different. Do you think our courts are becoming progressive because of these kind of judgments?
No, you're right. I think this is the best statement made so far by any of us. The hallmark of change is evidenced by the manner in which you deal with the situation in hand. And you are right. Yesterday, communications between a man and a woman would automatically be deemed to be something which was negative, or an affair, or something which was not required, or something that should not be done, or something that should be prohibited. So each of those concepts have gone down the window. And basically, you come around to a situation where today the courts are saying people who are working together, people who know each other, simply communications between them, simply emails between them, simply WhatsApp between them, simply Facebook acknowledgements, even to say like. I mean, you today have a situation where in Facebook you say like. Now, yesterday, any of these situations would have involved a kind of stigma against your character. But today, this approach of the court has actually paved the way for the thinking along these lines. And I think that this is where, when we discuss the nature of change in the world or the nature of change in India, you see, how do you make that change? It is these concepts. The primary issue today is not that laws are not in place or the policies are not in place or the courts are not doing justice, but it is mostly these mindsets which are really required to be changed across board. And the entire process of education, which involves not only school or college education, but education as human beings across, is made by these kind of judgments and these kind of statements by the courts, which actually go across surface to make people understand this has been said by the Supreme Court judge. This has been said by somebody who stands at the top of affairs as far as the country is concerned. This is somebody who's meting out justice. If they are saying it, it means there is something more to it. It means what I was thinking possibly may be wrong. So I do believe the power of persuasion and the power of mandate both stretch across from courts. And I think
that's very interesting that the observations of Justice Indira Banerjee and Justice Krishna Murari in response to the arguments that you presented before the court will have a bearing on, say, hundreds and thousands of cases of divorce which are being argued across the country in an environment where women are increasingly going out, working. In many cases, there is equal workforce participation in urban centers. You have a large number of women working and would have to face, let's face it, divorces are a fact of life. There's no running away from this fact. And a progressive approach by a higher court means that it has a trickle-down effect on the lower courts across the country, from Kashmir to Kanyakumari. And it in a sense, you can't actually give anybody respect, but I think it ensures an equal society, which in your way we should move towards in the coming days too.
I think I couldn't put it better than you, Tarun. I mean, you've actually summarized the entire sum and substance of what one would have wanted to say or what one thinks. That is exactly the point. Trickling down effect is exactly what you need. You need, as I said, the change of mindset, and that change of mindset can only come if forced and reinforced, not only in terms of a mandate, but in terms of persuasion and by the wisdom of the wise, which trickles down across to the people to say, look, maybe yesterday it was something I thought. Today, this is what either my peers or my seniors or wiser people are thinking. So I need to rethink myself through and come through a new way of thinking. And this new way of thinking is what we are all headed for.
So very interesting. In today's show, we got to discuss how Supreme Court of India is showing the way. Justice Indira Banerjee and Justice Krishna Murari are showing the way to other courts around the country. The other courts. And I want to a couple of last comments from you today. When you were arguing this matter, how positive you were that despite all the kind of allegations that were being made against this teacher, you would finally be able to convince the court of your stand.
I was very confident, and I actually, when I was briefed in the matter and I was listening to the entire situation, I said, this is preposterous. Some mails, some statements, colleagues in school together, and actually you can have anybody disentitle a mother from custody. But I would still repeat that I was nonetheless extremely satisfied that Supreme Court, considering it was an interim order, by the way, and ultimately you have the trial court granting the father. You did have a finding on that effect. You had the High Court reversing it. So the Supreme Court was so conscious of its role in the situation. The other side pressed so fervently. I must say that the counsel on the other side was fervently pressing for the fact that the children had been in the custody of the father and they were doing all right. But the court said, a young child, less than 5 years, where can she not be with the mother? The other side again presented, that's the younger child. There were two children. Yes. So basically, the eldest son was, as I mentioned, about 11 years of age, and the daughter at the point of time in question 3, and by the time this hearing happened, about 4. So the question was, the court was so cognizant of the fact and very firm, kept listening, kept discussing, but were very firm and steadfast on the basic preconditions. What is needed for the children? What is needed for the children? And that could not be displaced by any of the arguments towards the character of the woman. The court didn't go into the details at all. The court didn't discuss whether it was right or wrong or what it was. It didn't matter what the averments were. And in this case, by the way, the averments were very, very superficial. Only mails and communications. People go to much further lengths. This was not one of those cases which went to a higher length than that. But simply these averments, and yet the pressing and saying, oh, there are mails between them. They were talking 4 times a day. Now, this is the kind of conversation, and you rightly said, today's world of communication, people are talking to each other, whether working women or non-working women. What are you doing? And in these COVID times, in any case, what else is being done?
But communication can't be used as an excuse to level allegations.
Yes. So, I mean, communications to this extent, and then, of course, a couple of other features are pointed out, but I'm not going there. But communications today are a standard way of people coexisting. Of course, sometimes you may argue that it's too much, in the sense of kind of extra WhatsApp group and the chats that come across. And today, it's a world of too much bits of information. But that's another chapter. We are talking about communication between human beings. The only method of communication today is obviously not physical meeting. It is a way of discussing, meeting, and ultimately being able to continue to survive as human beings somewhere across the entire globe. So that is the current background that we are facing. And this is something that is indeed extremely rewarding and gratifying as a person, as a lawyer, to say that the court actually is cognizant of the fact, A, that this by itself is not enough. A. B, this is not there anyways. This is not a criteria to be taken into consideration. And this is the third thing, is the resonance across, that today and tomorrow, other courts across the country will not follow the same path.
Thank you so much for, in a sense, joining us today for Legally Speaking with Tarun Nangia. I am sure the viewers would find this enlightening. Also your arguments, and then the observations of Justice Indira Banerjee and Justice Krishna Murari. It would provide hope to so many mothers who are going through the painful process of divorce and are fighting for their children's custody. It is indeed heartening to know that you could be a part of such a case, and we could, through you today, hear so much. Thank you so much, viewers. Thank you so much, ma'am, for joining us on today's show. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.